7 requires reasonable religious accommodations unless it creates an undue hardship. How has the Supreme Court's 2023 decision in Roe versus DeJoy and other recent legal rulings in the U.S. changed the practical implications for workers? And what should professionals in this room know about it and to take into consideration? What are some of the tools or considerations that companies need to bear in mind? I think this first question I would like to start off with Martin.
Sure. Okay. Great to be with everybody today. How appropriate that we're holding this summit today. I think last night at about 11:15, we were all prayers of hope. And 11:17, I think it was, when that OG did his thing, we were all prayers of thanks, right? So great to be with everybody. It's great to be a New Yorker. Yeah, look, there's a lot going on in the legal space with respect to religion in the workplace, and I'll share some thoughts, both from the strict legal perspective, but also what I'm seeing from working with a wide array of clients. I'm a partner at McDermott, Schulte, and a big part of my practice is working with employers on workplace policies, procedures, programs, and religion in the workplace is becoming a larger and larger portion of that practice. So again, just to level set, as we all know, we just heard, right, Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of 5 factors: race, color, sex, national origin, and religion. And an employer is obligated to provide accommodations so that individuals can exercise their religion as long as it doesn't result in this undue hardship. Now, for many years, the Supreme Court pronounced in a landmark case back in 1977 called TWA versus Hardison that if the requested accommodation resulted in anything more than a, quote, de minimis impact on that employer, then that employer could reject the requested accommodation. And the individual would essentially be, kind of left to decide, do I want to stay here because they're rejecting this accommodation because it's crossed this relatively low threshold, right, of being de minimis. Now, these cases were and still are very, very fact-specific and requires initially a district court to determine, right, which side of the threshold did it land. The standard changed. The standard changed pretty significantly in 2023 in a case called Groff versus DeJoy. In Groff, the plaintiff was a U.S. Postal Service employee and requested to be exempted from having to work on Sundays because Sundays was his day of devoted to worship and to rest. The USPS declined that request and instead imposed disciplinary sanctions on Groff, ultimately leading to his decision to resign. Filed a lawsuit, and at the district court level and then on appeal to the Third Circuit, the courts found in favor of the employer, saying that his request and honoring that request of him not working on a Sunday could result in a de minimis hardship to the employer. And he appealed to the Supreme Court, and the court's composition, as we all recognize, changed pretty dramatically from 1977 to 2023 to its current form. And the court ruled as follows, that to deny a religious accommodation, an employer must demonstrate that, quote, the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business, right? So a much higher threshold than a de minimis threshold. What Groff really now stands for the proposition of is that the burden is more on the employer to show that in denying a religious accommodation, it's going to result in a substantial increased cost based upon their particular business, rather than this lower threshold of de minimis. Recent decisions at the lower court level have now applied the Groff threshold, and that's now become, kind of the new standard. And this is what's going on in the judiciary. The executive branch, the Trump administration, has made it clear that their focus in the workplace is to provide additional protections to individuals who want to exercise their religious rights. So the Equal Employment Opportunity Commission, the EEOC, some of you may have seen this just a week ago, issued their National Enforcement Plan. And this is a 5-year out plan of the areas that the EEOC intends on focusing their resources, what the EEOC deems to be important. And amongst a whole litany of things, which, conferences for another day we can talk about, what they are going to be focused on include the following: protecting workers' religious liberty rights to receive religious accommodations and be free from religious discrimination, harassment, and related retaliation. Right? So we can expect to see more EEOC involvement in cases or charges of discrimination where an individual feels that a reasonable accommodation request has been unjustified, turned down. So I think for the professionals here in the room that regularly deal with workplace issues, the thing to be aware of is certainly that the kind of legal standards I just walked us through has changed, and that under this administration, the EEOC in particular is going to be focused more on these types of issues. Where I see employers often getting tripped up in working on these matters with clients across the board is often when line managers, without the knowledge of what the legal standards are and or what the legal risks are outright just denying requests that may come to their attention without bringing it into the proper channels, whether that's human resources or legal, in-house legal, and are either dismissive or are outright denying these requests, right? We can talk a little bit more today about some of the fixes I would recommend that we do in this space.